Okay, so now again, just to sort of go over, because we know that civil litigation is when there's a dispute between two private parties, but I want to just go over the actual structure and procedures for civil litigation, right? So first off, when we're talking about people who are going to engage in this, you're called litigants, right? Those are two people, both individuals who are involved. The plaintiff is the one initiating the legal action, and the defendant is the one that the legal action is directed towards. Okay. Then, so when someone wants to sue someone, right? So if I uh, hired Thomas to build a shed, and Thomas's shed falls apart on the first day after he builds it, I go put stuff in the shed and it falls apart. And I said, well, Thomas, you have to fix this. Thomas, I'm not fixing it. You broke it. It's your problem. And then we go into court. As a plaintiff, I would be bringing damages against Thomas as a defendant. So it's not charges, but it's called damages. I'm seeking compensation for it. Okay. So the first party named in the citation initiated is in the litigation, that is legal action. The plaintiff is suing for received damages or compensation, usually money or wrong suffered. So you'll see something goes R versus and a defendant, right? So it'd be Dowdy versus Leakoff Construction, right? Or Leakoff, Thomas Leakoff, or Leakoff. Okay? That's how it appears when you first have it. Now, when you are participating in civil and legal action, it is not based upon the system. It's not based on the same system you use in criminal law. In criminal law, you make decisions based upon what's called a reasonable doubt. Here, you're basing on what's called the balance of probabilities. Weighing the evidence to decide whether the plaintiff or defendant's version of the events is more convincing or likely to be correct. It's not as high an onus. If you're talking about percentages, it's like a little over 50%, right? Which means I'm saying it's more likely or not you did the thing you did, right? Not that you did beyond a reasonable doubt. If we have evidence, and let's say my side as the plaintiff, I say I can prove that more likely than not, Thomas didn't fall through, I'd win. If Thomas proves to me more likely than not he did follow through and follow the procedures and he did nothing wrong, he would win. Right? So it's less because it's money. We're not really worried about it. So you can't sue people who are minors, which are under the age of 18 to 19, or you can't sue people with certain disabilities, right? So when people are sued, or let's say there's a situation, you might have what's called a next friend. It's an adult who represents a child or person who's has under disability needs a civil lawsuit. So next friend is for someone who is disabled. They can't defend themselves. This person steps in and acts as their defendant, or not a lawyer, but allows them to help in either the defense of that person. Guardian ad litem is the person appointed to act on behalf of a minor or person who's under a disability who is being sued, which means if Thomas worked as a student and he asked him to build a fence and he didn't do it and he fell apart, I sue him. I can't sue Thomas directly. He would have to have a guardian ad litem that would act as his representative for me to sue him, because you can't sue people who are underage and you can't sue people with certain disabilities. So I'm just going to show you what it looks like and just sort of break down what happens, right? So these are the stages of a set of litigation, right? So this is how it would happen in court. First is cause of action. Complaint or reason for suing, which means I file a complaint, right? Then there's a writ of summons in some provinces issued by the court, which means I then ask for the defendant. If I'm the plaintiff, I have a cause for civil action. Again, I made a shed, Thomas' shed broke. I do a writ of actions, which means a notice of action, which means I'm saying I'm suing somebody, right? Then there's a state of, after I make a writ of action, which means I'm going to let Thomas know I'm suing him, I make a statement of claim, which means I then tell in document what I think happened, right? Then after I make a statement of claim, Thomas can make a statement of counterclaim. He can say, well, that's interesting what he said. Here's what I think happened, right? Then there's the reply back and forth, right? Which means this is a chance where you could, at this point, come to some resolution, right? Thomas will say, yeah, okay, fine. Well, before we go any further, I think I'll pay you back. I'll fix it. I'll deal with it, right? This is at the reply section where you can sort of find some way to negotiate out of it. After that, you go, if both sides are still intended upon going to court, we have what's called a discovery of documents, which means we exchange documents. I show him what evidence I have to prove my point. He shows me his defense. The idea is to prepare for the court, right? I know what he's going to argue, so I can find a counter argument for it. He knows what I'm suing him for and what proof I have. He can find a counter argument for it. Again, sometimes because most cases are still out of court, during the discovery issue, one side understands the other side has an advantage or figures it out and either withdraws the case or they come to some sort of understanding, some sort of settlement, right? So examination both on both sides, then a pretrial conference, informal meeting attended by both sides and the judge or a master, which means before you go to court, the judge meets with you again and says, look, I've looked at, here's the situation, here's what you're suing for, here's what you're suing for. Do we really want to go to court? Can we resolve the situation other ways, right? So it's just a warning. And it says, okay, I want to also let you know that what we're going to allow in the court, what we're not going to allow in the court. So you have two options. You both agree to settle, you're done, you move on. Then you have trial by court, case presented and ruling delivered. So you go through the court procedures, you have evidence and you have witnesses, you have all those things you need in the court procedure, and the judge or jury makes a decision. If I lose, I can't appeal, but I have to appeal for a reason. I just can't appeal because I don't like the decision. There's got to be some reason. So it's either a mistake in law or a mistake in interpreting the law or something like that. I can then ask the judge to go above, look at the decision of the lower court judge, and to appeal the decision, right? So I kind of explain, I'm not going to go over it because, again, the situation, you can go into detail, but again, it just, the side tells you what's going on. So your summons is when you commence civil proceedings. Statement of claim is what you think is going to happen. Remedy is relief sought by the plaintiff, which means the plaintiff might say, I just want you to apologize. Well, no, I want some sort of compensation, right? And again, at this time, at any time during this court procedure before you get to trial, someone can just say, fine. So I can say, Thomas, I'm so angry. You just need to fix this, or you need to give me $200 back for the shed. Thomas goes, fine, here, take it. Solved, right? Because there's been a resolution. I got my money back. I'm not going to have to sue him for the money. So again, you can find out more about this, right? The only thing I want to add here is what's called third-party claim, and that's if the defendant may also claim by adding it, may also respond to the claim by adding a new party and by issuing a third-party claim. In this situation, the defendant denies liability either completely or partially and blames another party for the plaintiff's loss. This claim alleges that the third party, someone not named in the original lawsuit, may be liable for all or part of the damages that a plaintiff is seeking from the defendant. So, back to the thing, I ask Thomas, pay Thomas to build a shed. Shed falls apart. I'm suing Thomas. Thomas goes, whoa, wait. I didn't actually do this. I had another case. I was doing your shed halfway through. Something else came up. I had to finish my old project, so I subcontracted out to someone else who did the finishing touches, and they messed up, right? So I sued both of them, okay? Because that means that the person who did the final touches might have messed up. So Tom's gonna say, look, I've done everything right. I did everything by code, had everything done, but I need to take care of something else. So I went to a subcontractor, someone who I agreed who would help me out and do the job for me, and I would give him some of the money that I'm making. And I did a crappy job. I sue both of them. There's also something called claim made between parties on the same side of the lawsuit litigation. So sometimes the person who says, no, 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 but you told me to cut those corners, right? So when Thomas got Helen to help him out, Helen could say, no, 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 I'm suing you because you told me you need to cut costs, so I did. And that's why it's a shy job, right? So she could do a cross claim. So it can be kind of messy in those larger, uh, more diverse things because you could have some people on the same side, both defendants. However, to avoid damages, they may be saying it's actually that other person's fault, not mine. And again, I'm not going to go over all this stuff. I can't explain it to you. You can read it more in detail. So trial appeals court, blah, 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 blah. So I want to talk about something called a class action lawsuit, though. So a class action suit is a lawsuit initiated by a group of people over a complaint common to all. So you may see that if there is some sort of situation that's common to a product someone buys. I have a Kia Sportage. I find out that all Kia Sportages after 50,000 kilometers, the wheels come off, right? Melissa has a Kia Sportage. She goes, you know what happened to me too? Then we found out that more people happen to them over and over again. We would then sue as a group. The idea is that a class action suit draws more attention and it shows greater negligence, right? If this happened to every car, then the company would be responsible, right? A company could say, look, you're right, it does fall off. 1 out of every million times the wheels will fall off, right? That's just the nature of manufacturing. So then I couldn't claim a class action lawsuit because it's like, again, small numbers, not that big, but larger groups where it's impacted a bunch of people and it's consistency in that impact, I can then sue as a group. And then the courts will have to settle with, or the business will have to settle with something for all the people involved, not just the one person. You see that also with a lot of laws to do with environmental law, any laws that deal with businesses or things involved with large groups of people, they do it that way. You guys can read it on the civil court system. It's got blanked out here. But this talks about the different levels, right? You have small claims court, which you go up to, and that's between small amounts of money that you might want to get back. So they're not going to go it. I think it's cases up to $25,000, right? So if someone owed me a couple $100, I go to small claims court. I don't go to provincial court. But as it gets larger and larger, you go up where you've got the province of the territory or trial division. It involves lawyers heard by a judge alone or such a judge and jury. It involves class action lawsuits, and then you have the appellate division, which is the one that hears any decisions made by someone by a lower court that's appealing because their decision was meant to that someone's saying it was wrong. It was a wrong decision made. And it's heard by a panel of judges who listens to how the case went down, makes the decision according to law. Federally is the same idea, right? You have your superior court, then you have your appeal division, your trial division, the appellate division. The difference here is on top of the Supreme Court of Canada, which means they settle both. They can, if it goes that far, the Supreme Court of Canada can settle civil situations. They don't like to do so. They can say we're not listening to that case because they want to focus on what it is. Their job is to determine the relationship between individuals and the state, but they will hear several cases if someone says, look, this is a major issue. Okay, so how do you get out of civil court? What do you get out of it? Again, no one goes to jail, civil court. This is not debtor's jail. This is not the 1800s where we throw people in jail because they don't have any money to pay for stuff. We have what's called general damages, money. So one is called, I can never pronounce this word, pecuniary damages, which is a monetary compensation for losses that can be calculated, which means if Regina played in the WNBA and got paid their size of crap. So let's just say she was the highest paid player and that was $500,000. But when she was out, some fan went and smashed her knee, right? She couldn't play basketball anymore. She found out that it was Helen paid the fan to do it so she could get her spot on a team. Regina would sue for pecuniary general damages because she would say, look, I'm a basketball player. I made this much money this year. Statistically, average career of a basketball player in my age is 7 years maybe. So you need to calculate what I was making there, right? And let's say she goes, I'm a superstar. I've improved my stats every year, which means I probably will get a bump in salary. So she comes up with a calculation saying, you owe me $8 million because that's going to cover what I would have played if I'd been healthy on the average scale, right? Now, maybe Regina, as a basketball player, plays for 1 year, she's done, or maybe she plays for 20 years, right? But you would make your argument based upon this is the average you would make, right? The same way if Ryan was a surgeon who got paid $150,000 a year, and someone left something, he tripped, fell, and his hands got burned, and therefore he couldn't do surgery anymore. He would say, I'm a surgeon, I'd have a 30-year career, making this much amount of money, blah, 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 I'm owed this much. So it's calculated. You can calculate the cost, right? There's some formula you're going to make an offer and say, this is why I should get this much. Okay, so it's usually done by, you figure out the finances of it, right? So then you have non-pecuniary damages, compensations for losses that do not involve actual loss or money or are difficult to quantify. This is sort of like pain and suffering, right? I want my money because I've suffered in pain and suffering. If you see this picture here, you see a young man who's in a head brace because he can't move his neck, right? And they got screws to his head so he doesn't move. He could sue for pain and suffering, right? He could say, look, yes, I'm just a high school student, but now I have to go through that therapy, I have to wear that device. I may never walk right again. I can't sleep well. I get migraines. So it's hard to quantify, but I'd say you see for pain and suffering. And then the judges have to come with some sort of settlement. Here's a fun fact when we talk about court cases and we talk about the government. In Canada, we don't really have large sums of damages. In fact, when Sari Shatter's husband would come in, he had a very interesting saying. He goes, if you get a lot of money from a court case, you're really messed up, right? So if Thomas gets $10 million from a court case, that means he's completely screwed. And he cannot operate in society, and he needs that kind of money. Canada tends not to have large litigious cases. The United States, yeah, they'll see you for anything, right? And you know, we've always heard that case about someone who's like the case you hear about someone suing McDonald's when I was a kid. He sued McDonald's because the coffee burned him because coffee was too hot, right? I was like, well, what does that mean? Coffee's too hot, which meant, and that also kind of the reason why they designed new coffee lids to prevent spillage because people could sue. Okay. Aggravated damages are compensations for intangible losses such as humiliation or distress. So if you did something that made me look, so not only did Regina get her kneecap broken, because she did that, and because of shock of pain, she peed herself, and there was someone videotaping it, right? And put it on YouTube. Hey, pees herself on camera, what? Right? And so she could sue that not only was I physically hurt, not only did I lose my career, I was embarrassed by that. That someone, because of the pain, I just wet myself, and now someone put on YouTube and now made memes on it, and now I'm embarrassed. So now I want aggravated damages, right? You've done something to embarrass me. On top of that, I want more money, right? Again, harder to calculate. And you have special damages, which are compensations for out-of-pocket expenses. So special damages are, look, I had to pay for my new drugs, or I have to pay for a car rental. So Thomas smashes my car because he's just being irresponsible. I now have to get a rental car and pay a certain amount of money, I'm going to sue him for special damages, which means I got to pay for that car and my rental costs. So now you're going to cover that as well. Punitive damages are damages imposed to punish the defendant for reprehensible conduct. So that's a damage that you do to punish people, right? So sometimes punitive would be like, you've seen courses like, okay, Thomas, that was a horrible thing you did. You dumped water pollution into the ocean and you killed millions of people. You have to pay $500 million, right? Now that's way, again, Canada, you wouldn't get that, but it's meant to be punitive. It's meant to let everyone know that that behavior is unacceptable and I'm going to give a damage. So you might get like small general damages and then you might get a punitive damages on top of that. Like technically speaking, for general damages, it's only $50, but because you went and did something that is despicable, I'm adding on another $1 million on top of that because I want to punish you. The other side, it's called nominal damages. That's where it's minimal compensation to acknowledge a moral victory. So it could be something where you did something wrong, person may be broke, I said, fine, all I want is $1. Right? Just because you want to acknowledge that there has been a victory and the competition doesn't really matter. Then there's also what's called specific performance, which is a court requiring a party to fulfill the terms of a contract. So Thomas didn't fix my shed. I want my shed fixed. He says, no, I sue him. He's gonna come back and fix it properly, right? And on top of those special performances, I want 3 years of guaranteed service if there's a problem with it, which means to come back, there's a creek, it needs oil, he has to come back and take care of it, right? So those are things where I'm not looking for money, but I'm looking for satisfaction, right? I built something, I don't want to go find another contractor, I want him to fix the job he's supposed to do, and I want some sort of compensation for that. The next one is called injunctions, the court requiring a prohibition of an action, which means an injunction means if he has a company that's been doing this, the court could say, you can't have any more businesses operating that way. We can actually stop you. Sorry, guys, messages. How do you enforce in judgment? So how do you get people to pay, right? One thing is garnishment, which means the court can. One thing you could do is garnishment of wages, right? So basically, if you're not going to pay me money and I want to get it, I can garnish your wages. That's only a certain percentages. Now, the weird thing is that it depends upon what the wages are, they can touch. I'm going to talk about an American case, but I think it may also apply to Canada. So, you guys know who O.J. Simpson is? Oh, wow.
Yeah, I do.
Okay, excellent. So O.J. Simpson murdered his wife, right? And
another man.
Another man, right? Thank you. And he drove a Bronco. It's a whole thing. Went to court. Knife don't fit, bloody glove, all that stuff. So I'm going. So he was then brought to. So he was acquitted in criminal court, but then he lost in civil court, and he has to pay the family $25 million. He hasn't paid any of that because, as an NFL player, his pension can't be touched, right? And I think certain things as of his children can't be touched. So OJ is still going to golf courses and he still has money, but you can't touch that money. You can touch any other money he earns, but you can't touch it. So I think in Canada, garnishment is your wages, but if you are on pension, you can garnish your pension, right? It depends on it, and you can't be garnished the way that you can't survive. So it can take a portion of your money forever, but it can't be the portion that's so much that you as an individual cannot survive. Execution and seizure. If you owe something, they can just take your stuff. So I'll use another American case. You guys know who Bernie Madoff is?
Yes.
Thank you, Quinn. So Bernie Madoff was an individual who was considered to be a wizard, a financial wizard, who basically was running a Ponzi scheme. You guys know what a Ponzi scheme is? Not Fonzie,
I
but Ponzi.
do.
Okay. You want to explain, Quinn, what's a Ponzi scheme?
A Ponzi scheme is basically a scheme in which great rewards of capital are said to be given out. And when someone puts money into the whole scheme, that money is actually distributed to people who invested earlier into it. And
Right,
there's
so-
no actual money being made. It's just money's being transferred from people to people. So the person who's making the scheme can make the money. Another example, I believe, is DC Solar, which happened recently.
Right, excellent. So it's sometimes people call it pyramid scheme, which means if you all put money in, so Helen puts in money, and I said, guess what? Thank you for investing money. You'll make your money back. But what I do is I take her money and I pay you because you invested earlier. Right? So it looks like I get, so what Bernie Madoff did is that he was getting 20% returns all the time. So people are going there, doing it, right? And statistically, that's not possible, right? The market goes like this, right? This is the market. Up and down and up. You guys can see this, but it's up and down, right? His rates are going like that continuously. That doesn't work, right? You cannot just constantly making 20% returns. It's insane. That's because he was taking money and giving to new clients and getting new clients to come in and giving them money. And it was just a big old Ponzi scheme until he got caught. Because he had not invested any money. He had not done anything with the money. He was just basically shifting it around. Okay. And but also taking his commission, right? That once I made you money, I get a portion of that money as a commission. So I can take seizure, which means I could take your house, I could take your stocks, I could take things that don't belong to you or things that belong to you as a way of compensation, right? So Thomas can't pay me the things. Well, I want his money, so he has to maybe sell his car, or maybe I'll take his car, maybe I'll take his house, right? So there's some alternative things, and I talk about a motor liability insurance. So I think about for compensation, like everyone who owns a car gets insurance because I can't pay people directly. It'd be too much. And sometimes if I created accidents, I would have to pay. And that could be, rehabilitation, injury. Again, the more money you pay in a civil lawsuit, the worse the person is. So if I have to pay millions and millions of dollars because that person can't work, can't do anything, needs that money and needs it well. So that means I pay into a liability insurance that says that they will cover my costs. So I pay a certain amount a month and it will tell me, it will cover these types of accidents and these types of injuries. And sometimes I'll have to pay a portion of that money out. If my car gets stolen, it gets reimbursed. But any type of claim increases my, what's it called again? Premiums, right? So I pay 100 and some amount a month for insurance, right? So when you're a teenager, right, you first thing you pay a ridiculous amount of money, right? Especially if you're a male, you pay more because statistically men speed, right? But as you drive more and as you don't have accidents, it goes down and down and down and down and down and down and down. But if you have an accident, it goes right back up, right? We have no fault insurance. That basically means it doesn't matter who gets injured. People are compensated. There's no blame. But again, you have to pay for it. And again, insurance only covers certain aspects, right? It doesn't cover everything. It may cover, you guys remember a couple of years ago when there was flooding and people were driving their cars through the flood? So there was major ponding, right? Like where basically water was getting up to like almost the windows of a car, right? So some people would see that big old thing and they try to drive right through it. Is that a good idea? No, it destroys your car. You put your car through that and it's gone. Engine's gone, it's done, right? You couldn't claim insurance because they're not gonna cover you driving your car through a large puddle or like a large flooded area, right? Yep.
Both You mean both gas cars that use gasoline engines and electric cars, right? Both and different.
I don't know with electric cars. Because electric cars are a different type of engine. Gasoline are combustions. And if you drive a car through like water, it will ruin your engine. It won't work. It's done. Like the car is. I don't know about electric cars because they're non-combustion engines. They're battery powered. I don't know what they would do to the battery. It'd probably ruin it. I mean, think of it, if you drop your phone in water, what happens to it? If it's not IPX proof.
Shut down.
Right, it just, right? So, but either way, no insurer will pay for that. Now, if your car gets caught in a flood, maybe, right? Because that's not you doing something, right? Because everyone thought I'll just drive through it, I'll be fine. And it wasn't the case. So you saw when people were doing it, all these cars were getting stuck. Someone drove a Porsche through it, gone. Someone drove a truck through it, gone. Right? Like it's not salvageable. Next one of compensation is workman's compensation. So if you get worked injured at the work and the work's unsafe, you get a certain portion of your money to heal from injury. So it's not everything, it's like the entire salary. Like it's from 70% upward of the money you would have made gets compensated. And sometimes it's criminal justice compensation, but I wouldn't worry about that too much. And I think we are, there's just some alternatives to dispute resolution. So sometimes it's negotiation, which means instead of going to court, you hire a negotiator to resolve the issue, right? Because courts are expensive, court costs are expensive, and if you lose, you might have to pay the person who came at you, it's court costs. So if I'm a plaintiff and I sue Thomas, and we both will go to court, Thomas can countersue me for costs, which means if he wins, I got to pay for my costs and his costs, right? And it's expensive, which is lawyer fees, investigations, like anything you need to bring to court comes out of your own pocket. So negotiations are easier, right? Mediation is a third party in there, and the part of mediator, their job is to listen to both sides and to provide a solution, right? Now, the solution is non-binding, okay? So it's usually a third party that everyone agrees to, and the mediator comes in and they listen and they say, here's what I think should happen, okay? The next one, I think, is arbitration. Arbitration is a neutral third party, but it's binding, right? So negotiation is you both sides sit down, they talk about it, try to figure out something, figure out a solution, but it may not work. Mediation is Helen wants to go see the latest Fast and Furious film, and Regina wants to go see latest James Bond film, right? That's why I'd be our mediator, right? And I sit down and I ask questions and they both present their sides and I say, you know what? I think what you should do, instead of saying these movies, you could agree to see each other's movies in different weeks. Like you both agree to go to movies for the next 2 weeks. One goes to Fast and Furious with your friend, the one has to go to the other one friend, right? That's my immediate response, right? You'll say, I'll go to hell, well, you know what I'm talking about. I'm not seeing that movie, you can't make me. Okay, all I do is mediate. If I'm an arbitrator, then I come and I say, well, I looked at the cases, and quite frankly, Fast and Furious sucks, and they're horrible movies, and you're gonna rot your brain. Regina's right, go see the movie with Regina. And Helen is bound to see it. She can't say, well, I don't like it, right? So arbitration requires a truly neutral party, and lots of parties don't like that. I mean, some people like arbitration because it's just someone coming in and just selling it, and that's it. People prefer mediation because mediation does give and take, and you have to both agree to it. You see something with arbitration for sports teams and for that kind of negotiation, for damages and for civil cases. That's when you want to avoid a judge, right? You figure you've got enough evidence to back you up, and an arbitrator who is, which means third party, which means they're neutral. Like I can't choose the arbitrator, right? They chose me because Wald likes us both, so he's probably fair, right? Or Wald hates us both, so he's probably fair. Okay? But if I say, well, Wild likes Helen more than likes Regina, that's not a good negotiator, not a good mediator, and not a good arbitrator. Has to be someone neutral in between. And I think that's it for the thing. So that guys, just a basic structure, but if you want to look it over, read it on your own. It just sort of breaks down what you need to know for how civil cases work, right? And again, it's something, if you need to sue somebody, I get it, but the alternatives are always better because they're just less expensive. It is cheaper to find someone to be a mediator than it is to find a lawyer, because lawyers could charge you anywhere from $200 to $300 per hour. And it's billable hours, which means every time they work on something, they just record it. And that means if it takes 3 or 4 hours to get your case ready, that's at $400 a pop, an hour. That's, my math is so bad. Let's say almost $2,000. And that's just for preparation. That's not court time. That's not, oh, I need to look at this. I need to pull this report. I need to do all that stuff. You have to pay for that. So you can have legal fees going up to several $1,000s. You could still lose. All right? Okay, any questions? Awesome.